Welcome back to the deep dive. We've got a pile of sources here on, well, a really thorny topic in commercial law. It's the infamous battle of the forms.
Oh, it's definitely thorny and incredibly common. You see it every day. Buyer sends a purchase order, seller sends back their form, and surprise, the fine print doesn't match.
Right. And back in the day, pre-UCC, that was a huge problem because of the common law's mirror image rule. Any difference, no matter how small, meant no contract, just a counteroffer.
Yeah.
Killed the deal.
Exactly. It just didn't work for modern business. People were acting like they had a deal, but the paperwork said otherwise. So the Uniform Commercial Code, the UCC, came along.
And specifically, Section 2207 for sales of goods. Right?
That's the one. It fundamentally changed the game, telling that old mirror image rule to, well, take a hike, basically.
So our goal today, our deep dive, is to really wrestle with 2207. We need to give you, the listener, a clear path through it.
Yep. Three main things to figure out. First, under 2207 subsection 1, when do we even get a contract if the forms clash? Second, if we do have a contract, what happens to those extra or different terms? That's subsection 2.
And finally,
Subsection 3. That's kind of the safety net for when the writings are a total mess, but the parties act like there's a deal anyway. They start shipping, paying, performing.
got it. Okay, let's jump into subsection 1 then, the formation issue. So I send you an offer, say, for 100 widgets. Your acceptance comes back, looks mostly okay, but it adds a new payment deadline I didn't propose. Do we have a contract right then and there?
Under the UCC, yeah, generally you do. That's the big shift. The rule in 2207 says a definite and seasonable expression of acceptance works as an acceptance even if it has additional or different terms.
Wow. Okay, hold on. That feels really pro-contract formation. The UCC seems to be saying, look, if the core stuff matches goods, quantity, price, roughly we're assuming you intended a deal, the fine print is secondary. Why?
Well, it's all about commercial reality. Think about it. Businesses often start relying on these deals immediately. They order materials, schedule production. As soon as that acknowledgement form arrives,
Right. They act first, read the boilerplate later, maybe?
pretty much. The UCC drafters wanted to prevent parties from using tiny discrepancies in the forms as an excuse to back out later, maybe when the market changes. It prioritizes the actual intent to make a deal.
Okay, that makes sense from a business perspective.
Right.
But surely there has to be a way for the party receiving the offer to say, no, wait, I absolutely need you to agree to my specific new term. Like, if I insist on payment up front, how do I avoid accidentally forming a contract without that term?
Ah, yes, that's the crucial escape hatch. It's called the conditional acceptance proviso. A contract is prevented under 2207 only if the acceptance is expressly made conditional on assent to the additional or different terms.
Expressly made conditional. That sounds like you really have to spell it out, doesn't it? It can't be buried in paragraph 17b.
Absolutely. Courts require really clear, unambiguous language, something like, our acceptance is expressly conditioned on your agreement to all terms contained herein. Just standard boilerplate saying subject to terms on reverse usually isn't enough.
So you need language that basically screams, stop. Don't proceed unless you agree to these specific changes.
Exactly. If you don't use that kind of strong limiting language, then boom, you have a contract under 22071, and now you've got to figure out what to do with those conflicting terms using subsection 2.
Perfect segue. So we've established a contract exists under 1. Now we move to subsection 2 to deal with those messy additional or different terms. And the first step here is status.
Correct. The analysis under 22072 completely depends on whether the parties involved are considered merchants.
Okay, let's handle the simpler case first.
Yeah.
What if one party, or maybe even both, are not merchants? Like a weekend woodworker buying a special tool from a big supplier. What happens to the extra terms the supplier stuck in their confirmation form?
In that situation, those additional terms are treated just as proposals for addition to the contract. They don't automatically become part of the deal.
Proposals.
Yeah.
Meaning the original offer or woodworker has to actually see them and say, okay, I agree to that extra term.
Precisely. The law assumes non-merchants aren't poring over fine print, so it protects them. The new term only gets in if it's affirmatively accepted. It's not automatic.
Makes sense. Okay, now for the main event, the real battle of the forms. When both parties are merchants. This is where it gets complicated, I imagine. If we have a contract under 1, what's the default rule now for including additional terms between two pros?
Between merchants, the default rule flips completely. Those additional terms automatically become part of the contract.
Whoa, automatically. Without the original offerer doing anything.
Yep. Unless, and this is a big unless, one of three specific exceptions in 22072 applies. The UCC basically presumes merchants know what they're doing, read their forms, and understand standard industry practices.
That sounds, frankly, a bit dangerous for the person who sent the first form, the offerer. If I send my standard purchase order and your acknowledgement form adds, say, a hefty late payment penalty, am I just stuck with that penalty unless I shout no?
That's pretty much it. That late fee term is in the contract automatically unless you can show one of the three exceptions applies.
Okay, what are these magic exceptions? The escape clauses under 22072.
There are three. A, if your original offer expressly limited acceptance strictly to its own terms, like saying acceptance limited to terms herein.
Okay.
B, if the new term materially alters the contract. This is the big one.
We'll come back to that. What's C?
Or C, if notification of objection to the term has already been given or is given within a reasonable time after you receive the form with the new term. So you can shout no effectively.
Got it. Let's drill down on B, material alteration. That seems like the most litigated one. The UCC comments mention surprise or hardship. How do we know if a term crosses that line? What makes an alteration material?
Yeah, that's where a lot of the fights happen. Courts generally look for terms that would significantly shift the economic risk or mess with standard legal remedies in a way the other party wouldn't reasonably expect.
So, like, changing the delivery date by a day or two probably isn't material.
Probably not. But adding, say, a disclaimer of all warranties when warranties are standard in the trade, or shifting liability dramatically, or adding a clause requiring arbitration in a really inconvenient place, those are usually material. It's something that a reasonable merchant would probably want to negotiate specifically, not just have slipped in.
Okay, let's use a really concrete, visceral hypothetical to make this distinction super clear.
All right, let's hear it.
Imagine a huge pharmaceutical company. They offer to buy a very specialized, complex chemical reactor. Let's say it costs $10 million. Big piece of equipment.
Okay.
The seller sends back their standard acceptance form. It looks fine on the front, but the boilerplate on the back includes two new terms. First, any dispute must be settled by mandatory binding arbitration in Nome, Alaska.
No, okay, that's a remote.
And expensive to get to.
Yeah.
Second term, the seller limits their liability for any consequential damages. Think lost profits if the reactor fails to a maximum of $10,000 on a $10 million machine.
Oof. Okay, both of those sound like they could cause some serious surprise or hardship.
Definitely. Let's analyze this using our structured dialogue. First, what are the legally dispositive facts regarding material alteration here?
The key facts are the seller's acceptance form contained two new clauses not in the pharma company's offer. One, mandating binding arbitration in Nome, Alaska, a very distant and costly forum, and another capping consequential damages at $10,000 for a $10 million reactor.
And what was the core legal issue that 22072 forces us to confront with these specific terms?
The issue is whether either of these terms, the Nome arbitration clause or the drastic liability cap, materially alters the contract under 22072B, meaning would they result in surprise or hardship if included without express agreement.
What rule do we apply to decide if they get included?
The rule is that between merchants, an additional term is excluded if it materially alters the original bargain. A material alteration is one that significantly shifts risk or remedies beyond what's customary or reasonably expected.
All right, let's apply that. What was the court's likely analysis here for each term?
Well, for the arbitration clause, forcing litigation in Nome, Alaska is almost certainly a material alteration. It imposes significant cost, inconvenience, and logistical burdens on the buyer, shifting the dispute resolution landscape dramatically. That's surprise and hardship.
Makes sense. What about the liability cap?
That one's even clearer, I'd say. Limiting consequential damages to $10,000 on a $10 million piece of equipment, that's 0.1% of the value, is a massive shift of economic risk. If that reactor fails and causes millions in lost production, the buyer bears almost all of it. That's definitely hardship and likely surprise. No reasonable buyer expects that low a cap without it being explicitly flagged and negotiated.
And therefore, the conclusion.
The conclusion is that both the Nome arbitration clause and the $10,000 consequential damages cap would be knocked out of the contract under 22072B as material alterations. The contract for the reactor itself still exists, but without those two specific seller-favoring terms. UCC gap fillers would likely apply instead for dispute resolution and damages.
That hypothetical really clarifies the surprise or hardship standard. Okay, so that covers additional terms, new things added in the acceptance. But what about different terms? where my offer says one thing, like standard warranty included, and your acceptance directly contradicts it, like all warranties disclaimed.
Ah, yes. Different versus additional. This is actually a huge point of confusion and disagreement among courts interpreting 2227.
Okay, so now we're really in the weeds.
Pretty much, because technically 2207, which we just discussed with the exceptions, only talks about additional terms becoming part of the contract between merchants. It doesn't explicitly say what happens to terms that directly conflict with the offer.
So what do courts do?
The majority approach the prevailing view is what's called the knockout rule.
The knockout rule. Sounds decisive.
It is. Most courts hold that when terms in the offer and acceptance directly conflict, they knock each other out. Neither term becomes part of the contract.
So in our warranty example, my warranty included term is out, your no warranties term is out. Then what?
Then the court fills the gap with a standard term from the UCC itself. In this case, probably the implied warranty of merchantability would apply by default. The conflicting terms essentially cancel each other out.
Okay, that's the majority knockout rule. Is there another view?
Yes, a minority of courts disagree. They try to treat different terms the same way 22072 treats additional terms. Under this view, the term in the acceptance, the no warranty clause, would be seen as a proposal that fails if it materially alters the offer, which it likely does. So the original offer's term, warranty included, would control. But again, that's the minority view. Most jurisdictions follow the knockout rule for directly conflicting terms.
That's a really critical distinction. Knowing whether the knockout rule applies makes a huge difference to the final terms. Okay, one last scenario. What about the real doomsday situation? The forms are just wildly price, quantity, delivery, everything is mismatched. So different that maybe no contract even gets formed under 2207.
Right, maybe the acceptance wasn't definite enough, or maybe it was expressly conditional, but the other party never assented.
But despite the paperwork disaster, the seller ships the goods anyway, and the buyer accepts and pays for them. They start acting like they have a deal.
Now you're talking about UCC 2207 subsection 3, the contract by conduct provision.
So the law recognizes a contract even if the forms failed.
Exactly. The UCC says conduct by both parties, which recognizes the existence of a contract, is sufficient to establish one, even if the writings don't agree. Commercial reality, again, people act on deals.
Okay, so performance creates the contract.
Hmm.
But what are the terms of that contract? The forms are still a mess of contradictions.
Here we see the knockout rule principle again, applied even more broadly. Under 2207, the terms of the contract formed by conduct consist only of those terms on which the parties' writings actually agree.
Only the terms that match.
Only the terms that match, plus any supplementary terms provided by the UCC itself, the default rules or gap fillers, everything else, all the conflicting terms from both forms gets knocked out.
So subsection 3 isn't just about forming a contract through conduct, it's also a massive term stripping tool. It basically says, you couldn't agree on the details beforehand. Fine, we'll use only what you did agree on, plus the standard UCC rules.
That's a perfect way to put it. It forces the parties back to common ground, and UCC defaults if their paperwork was too contradictory, but their actions showed intent to deal. It's the ultimate fallback.
This was incredibly helpful walking through each part, but it's a lot to juggle. To make sure our listeners can really apply this, maybe on an exam or in practice, can you synthesize all of this into a clear step-by-step checklist? How should someone approach any battle of the forms problem?
Absolutely. Here's the diagnostic checklist you should run through every single time. Step 1. Formation under 22071. First, look at the recorded acceptance. Is it a definite and seasonable expression of acceptance? If yes, you likely have a contract unless that acceptance uses very clear language making it expressly conditional on assent to its new terms. If no contract forms here, either not definite or expressly conditional without assent, jump straight to step 4. If a contract does form under 1, proceed to step 2.
Okay, step 1. Do we have a contract based on the writings? What's step 2?
Step 2. Status and term type. If a contract formed in step 1, now figure out who the parties are and what kind of terms are at issue. Are both parties merchants? If not, any additional terms in the acceptance are just proposals. If both are merchants, then identify. Are the non-matching terms additional, adding something new, or different, directly conflicting with the offer?
Got it. Merchant status and term type, then step 3.
Step 3. Inclusion of terms between merchants. 22072. This is where you apply the rules based on step 2. If you have additional terms between merchants, they automatically come into the contract unless one of the 3 exceptions applies. A, the offer limited acceptance to its terms. B, the term materially alters the contract's price or hardship. Or C, objection was already given or is given reasonably quickly. If you have different conflicting terms, apply the majority knockout rule, both conflicting terms are out, and UCC gap fillers come in.
Right. Apply the exceptions for additional terms, knockout rule for different terms, and finally, step 4.
Step 4. Contract by conduct, 22073. You only get here if no contract was formed back in step 1 based on the writings. Ask, did the parties start performing anyway? Did the seller ship? Did the buyer accept or pay? If yes, then a contract is formed by their conduct. The terms of this contract are only those terms on which their writings agreed, plus UCC gap fillers. All conflicting terms are knocked out.
That 4-step framework formation, status type, inclusion, conduct, seems like a really solid way to tackle these problems systematically. It really shows how 2207 tries to save deals while being fair about the terms. It's pragmatic, not purely theoretical.
Exactly. It recognizes that business moves fast, paperwork isn't always perfect, but deals still need structure and predictability. It avoids technicalities, killing agreements, and uses objective tests like material alteration to police the fairness of the terms that survive.
It provides a structure for that unavoidable friction. Okay, before we wrap up this deep dive, here's a final thought for you, the listener, to chew on, building on that idea of material alteration. We said the test is surprise or hardship. But what happens if a certain clause, maybe one that seems pretty harsh, like a very short warranty period or a strict return policy, is actually standard practice within a specific industry? Everyone in that trade includes it in their forms. Does that industry custom change the analysis? Can a term be standard practice and still be a material alteration, causing hardship? Or does the custom effectively eliminate the surprise element, making the term enforceable even if it seems one-sided?
Ooh, that's a really good question. It pushes the boundary. If something is truly standard trade usage, it's arguably no longer a surprise. The UCC does value trade usage. So it's possible a term that looks harsh in its face might survive a material alteration challenge if it's genuinely how that particular industry operates. It complicates the analysis for sure.
Something interesting to think about next time you see boilerplate language. Thank you so much for navigating us through the complexities of UCC 2207 today.
My pleasure. It's a vital piece of commercial law.
We hope this deep dive leaves you feeling better equipped to handle the battle of the forms. Until next time, keep exploring. Drafting question right there.
Thanks for diving deep with us today.